I take this opportunity now to welcome CS.
Thank you very much, Honorable Chair and members. My name is Muthomi Thiankolu. I'll be making the opening statement on behalf of the Cabinet Secretary. I'll do 30 minutes, and my colleague, Mr. Mawire, will do 10 minutes. Unfortunately, sometimes my eyes is challenged, so I don't mind, Chair, if you interrupt me at the 30-minute mark, so that Mawire, because I might not be able to see the screen as clearly as I should. Honorable Chair and members, we have been wondering, and we have read this motion with a lot of keenness, and we've been left wondering why we are here. Of course, we know the simple answer is that there is a motion before the House, and it was sent to this committee to investigate. Here is why we've been wondering, Honorable Chair, why we're here. The motion before you has 3 allegations. Allegation number 1 relates to the Constitution. Allegation number 2 relates to alleged crimes at the national law, which unfortunately the evidence given is evidence that arises from personal cases about love and affection. And unfortunately, to the extent, unless that allegation is dropped, allegation number 2, we have to confront it. And if, as I will show you shortly, it is about love and affection and personal matters, then unfortunately we must confront it, even though it is sad that a committee like this would have its time being spent on such a matter. And number 3, we are here because it is alleged that the Honorable Linturi is guilty of gross misconduct. Honorable Chair and members, for you to uphold this motion, you must be satisfied on the material that will be presented by both sides that the Honorable Linturi has committed a gross violation of the Constitution, number 1. 2, that there are serious reasons, not frivolous reasons, not reasons tied to unrequited love and affection, that warrant a belief he has committed a serious crime under national law. And of course, you must be persuaded that there is an act or omission, a specific act or omission on the part of the Honorable Linturi that constitutes any of these 3 things, either a gross violation of the Constitution or a crime under national law or gross misconduct. We have, in our response, Honorable Chair and members, that we filed yesterday, presented before you a decision of the Supreme Court under Annexure number 7 in our BADO, specifically on pages 132 and page 190 to be more precise, on what the apex land court in our land has said is the threshold that must be satisfied when you're seeking to remove a state officer from office for allegations such as the one before you. And when you read it, I will invite you to note that 1, there must be a specific act, a specific omission, attributable to the cabinet secretary that is in question. I use the word specific, not nebulous and broad and vague and amorphous. Number two, that act or omission which you must be satisfied has been committed, there must be a nexus between it and the cabinet secretary, which is to say, contrary to some of the submissions I've had, it is not a matter where you say some guy must be hanged for this, somebody must be crucified for this. No. The Supreme Court has said there must be a nexus, a link between the cabinet secretary and the matter in question. When you read that decision, I will invite you to note it also has certain evidential thresholds. It is very easy to allege things. Proving things is where things become a bit more serious. And the Supreme Court has set the standard in flyer number 7 of our Bado. The linchpin of this case before you, Honorable Chair and members, is quote unquote that the Honorable Linturi approved the procurement and distribution of fake fertilizer. So for you to uphold this motion, you must be shown by way of evidence, not nice English, not high-sounding political speech, that the Honorable Linturi, quote unquote, approved. Cabinet secretaries make their approvals in writing. That's what our Constitution requires. We'll be interested to be shown the approval in question. Because without that approval, then the allegation must fall on its face. We will be urging you when we get there, Chair, to ask yourself whether, as a matter of law and fact, two things, law and fact, whether the Cabinet Secretary for Agriculture or indeed any other Cabinet Secretary is allowed, as a matter of law or fact, to approve procurement decisions, whether as a matter of fact the Honorable Linturi approved or in any other way engaged in any act or omission that can warrant the accusation that he approved the procurement of fake fertilizer. When we get there, Chair, we'll urge you to read document number 3 in our Bado, and document number 10, and document number 21 in our Bado. And we'll be urging you to check and to find that when you read those documents, one, it is clear that the NCPB is a semi-autonomous government agency with its own board, with its own bureaucracy that is legally and factually immunized from ministerial control of the type that is alleged before you. We invite you to note, because the allegation is one of approving procurement of fake fertilizer, we'll be inviting you to note from document number 3 and document number 10 and document number 21 that there was no tender document for procurement of fake fertilizer. On the contrary, on the record before you, the procurement in question was, quote unquote, to procure fertilizer that meets the standards set by the Kenya Bureau of Standards. You will know from those documents that the accused person before you even took steps, as per the document number 21, to remind that semi-autonomous government agency that they had to procure fertilizer that meets the specifications and standards set by the Kenya Bureau of Standards. Chair, this brings me to allegation number 2, which I said it is sad. We may want to wish this away. Allegation number 2 tells you that there are serious grounds for believing the Honorable Linturi has committed a crime under national law. What is the material that has been placed before you at pages 15 to 17 in support of that allegation? I mean page 15 to 17 of the motion before you. It is a list given there of court cases between the Honorable Linturi and the Honorable Member for Aldai constituency, which in the mover's own words, these are not my words, they are personal, civil, family, and commercial disputes. So it is not as Honorable Chair that I brought a matter of love, affection, and personal vendetta before you. It is ground 2 of the allegation on the record. All those 12, 15 or so cases cited there are personal disputes between the Honorable Linturi and the Honorable Member for Aldai constituency. And when we get there, the million-dollar question is, if this is not a trivial matter of love gone sour, how did the mover of the motion use material of personal family disputes as the core basis upon which an entire allegation number 2 of his motion is based? But more importantly, when we get there, Honorable Chair, we have produced before you 9 decisions of various courts, ranging from the Court of Appeal, going to the High Court, going to the magistracy, about all those so-called personal, family, and commercial disputes that form the anchorage for ground 2. And when you read the judgments and rulings and orders we have placed in document number 11 all the way to 19, the common denominator is that the courts have ruled all those disputes in favor of the Honorable Linturi. So the million-dollar question, Honorable Chair, yes, let's assume a motion like this can be based on personal court disputes. Does it mean if someone loses court cases, they have lost at the Court of Appeal, which is the highest court on those matters, they can't go to the Supreme Court? They have lost at the High Court. They have lost at the Employment and rather at the Environment and Land Court. They have lost before all the magistrates of this republic, sitting in different court stations. How can it then material that the courts have ruled in favor of the Honorable Linturi form the basis for ground 2 of the allegation before you? You have been told because, again under ground 2, because of those family cases, the Honorable Linturi is facing an imminent arrest, imminent prosecution, and whatever. We have already placed before you a letter from DCI, of course flowing from the countless victories the courts have given Honorable Linturi, in which the DCI says they have investigated those matters and they have forwarded the file to the DPP. The DPP has reviewed all those files and advised, quote, unquote, they be closed with no further police action. So it is up to you. Who do you believe? Is it the DCI who has written, confirming, and he didn't write yesterday? It was way back last year, more than a year ago. Who do you believe? We will be submitting before you, Honorable Chair, that this mover of this motion is a proxy, and specifically a proxy of the Honorable Member for...
Chair, there are some words that we shouldn't allow to use. Let me just explain what describe somebody as proxy. Honorable Omanya, say your point of order. I think we should use a language that is acceptable and not describe anyone in a manner that degrades them.
So that we don't waste time, I'm happy to withdraw the word proxy, Chair. I would also suggest when the interjection my clock be stopped because they eat on the time. So I will rephrase, Honorable Chair, and say that the real mover of this motion before you is the Honorable Member for Aldai. We shall play before you when we get there video evidence, specifically video number 4, that confirms that. We shall invite you to look at all the cases that form the basis of ground number 2, of allegation number 2. They are all cases between the Honorable Linturi and the Honorable Member for Aldai. We will be asking you to look at page 252 on document number 10 of our BADO, which will confirm to you that this allegation is actually a lie. And it confirms the DCI, the ODPP, closed all these matters with a formal recommendation for no further police action on the 31st of May last year. And then, of course, we'll be asking you, Honorable Chair, when we get there, all these so-called family, criminal, civil, and family and commercial disputes, they were matters that the House considered when it approved the Honorable Linturi. Is this motion seeking to reopen a decision already the House made to the extent that it has that ground 2 of the motion? Is it seeking to reopen a matter the House considered, cases it considered, allegations it considered, and nonetheless approved? And when we get there, we'll be humbly suggesting to you, it is not possible. A cabinet secretary cannot be removed from office on account of matters that the House already considered in making the decision to approve their appointment. And while on that matter, Honorable Chair will also be telling you, all those family law disputes anyway revolve around acts and omissions that took place or allegedly took place before the appointment of the Honorable Linturi as a cabinet secretary. So again, the question we'll be asking you, does Article 152 of our